Hello, I'm Kirsteen Shields and I'm a lecturer at the University of Dundee. My area of expertise is public law and human rights, and the EU speaks to human rights through the European Charter of Fundamental Rights and the European Convention of Human Rights. And I'm going to focus on the latter. Tobias Locke has already spoken on the European Charter. The EU speaks to the ECHR, the European Convention on Human Rights, indirectly, but very significantly. The ECHR was drafted in 1950, so it came about in the post-Second World War period, and it was specifically designed to limit states' power, so to limit what states can do to their own populations. And that was significant given the timing and given the background whereby discrimination and persecution was mandated through German laws. So the ECHR specifically created a moral code and, if you like, a common constitution amongst modern European nations containing key rights. So within the ECHR we have diverse rights. We have the right to freedom from slavery, the right to freedom from torture, the right to freedom from inhumane and degrading treatment, for example. We also have rights to education, the right to property, the right to freedom of expression, and other rights. It also has what's known as the right to individual petition, which is a very significant right because it creates a pathway for UK and citizens of member states. It creates a pathway for them to take a case to Strasbourg. That can only happen once all of the domestic avenues for a legal remedy have been fully exhausted. And then an individual in the UK can take a case to the European Court of Human Rights. We've had very interesting and significant jurisprudence emanating from the European Court of Human Rights in Strasbourg. For instance, we have the decriminalisation of homosexuality, or we have limits on police powers, so affecting the police forces shoot-to-kill policies, for instance. We also have significant jurisprudence concerning the right to freedom from inhumane and degrading treatment. For example, the case of Z and others in 2001 concerned 4 applicants who claimed that the state should have intervened earlier in their childhood to take them into care. The 4 applicants have been living in appalling conditions, and they claimed that local authorities had known about these conditions for at least 4 years before acting positively to intervene to take them into care. And the European Court of Human Rights agreed that there was in that situation there was a positive obligation on local authorities, on the state, to intervene and prevent violations of the right to be free from inhumane and degrading treatment. Now, that case had reverberations throughout UK courts. It's been cited as an authority throughout courts and in the House of Lords, and therefore it has an impact on a far greater number than just those directly affected by the case. So, leaving the ECHR, withdrawal from the ECHR, UK citizens are going to lose that pathway to the Court of Last Resort in Strasbourg. However, leaving the EU does not automatically mean leaving the ECHR. However, what it does, as these are separate institutions, however, it does make Brexit and leaving the EU makes leaving the ECHR easier and therefore far more likely. However, it should also be treated as an independent issue whether Brexit occurs or the extent of Brexit is yet unknown, and leaving the ECHR may happen independently, and that would happen through the repeal of the Human Rights Act and the replacement of the Human Rights Act with a British Bill of Rights, which does not contain this link to the European Convention of Human Rights, and that would have significant repercussions and a significant effect on the rights of individuals in the UK.